honor to be welcoming Sabine Jansen on the virtual floor today. Sabine, if you could unmute yourself and turn your camera on. Thank you.
Hello. And then I hope Marie will put in my slides. Yeah. I wait for that. Yeah. Well, it should be full screen, but I just start. So my report is also, I have to tell you, my report is also available on the excellent database of the SOGICA website. Okay. In 2011, we launched the Fleeing Homophobia report, a study into the handling of asylum claims based on sexual orientation and gender identity in Europe. And following this report, the Dutch Council of State asked questions to the European Court of Justice on how to deal with these types of claims. And this led to the judgments XYZ from 2013, and with main outcome was it's not allowed to expect people to exercise restraint in the expression of their sexual orientation. And it also led to the judgment ABC from 2014, with the main outcome: explicit questions on sexual practices are not allowed in assessing the credibility of sexual orientation, nor porn is also not allowed, nor decisions based solely on stereotypes, for these would violate the right to dignity and the right to privacy. In my research, in my research Pride or Shame, I investigated what changed in Dutch LGBTI asylum policy and practice after these judgments. At the office of the IND, the Dutch Immigration and Naturalization Service, I've examined files in which the decisions were taken between October 2015 and April 2016. From this 6-month period, I identified 267 LGBTI cases. There must be more, but as I had to find the files one by one from the system, it was not doable to search all files from Syrians and Albanians. 40 of the files I have studied in full. Oh, sheet two, please. Marie, if you could, yeah, great. Most of the claims, or 63% of the 267 files, were ultimately granted refugee status, which is a lot, which is more than average in the Netherlands. So that's good news. And 37% were rejected. I also found that 85% of the rejected claims were rejected on LGBTI asylum claims were rejected because the sexual orientation was found not credible. I didn't find cases in which the gender identity was not believed. The number of rejections of LGBTI asylum claims for reasons of incredibility of the sexual orientation is nowadays much larger than it was in the past. In the article From Discretion to Disbelief, Jenny Milbank from Australia writes that once other obstacles for granting status to LGBTI asylum seekers have been removed, there is a shift in focus towards doubt about the credibility of the sexual orientation. And this trend is also present in the Netherlands and in other countries. Before the judgments, XYZ and ABC applicants were mostly rejected on other grounds, like, for instance, discretion. It's recognized in Dutch asylum policy that some countries are so dangerous for LGBTI people that they are granted refugee status right away, independently of their personal story. For instance, Uganda, Iraq, and Chechnya. LGBTIs who flee those countries can only be rejected for incredibility of their sexual orientation or gender identity. It's interesting that the sexual orientation and gender identity of LGBTI asylum applicants from homo or transphobic countries where same-sex sexual acts are not criminalized, for instance, Azerbaijan or Cuba, is almost always believed in the Netherlands. Their claims are mostly rejected because the narrative is not considered serious enough. The main outcome of my research, and at the same time the main problem in the way the credibility of sexual orientation is assessed, and the fact that in this assessment several stereotypes are being applied. The main outcome, the main problem is the way, yeah, of course. Sheet 3, please. Following the judgment ABC of the Luxembourg court, a new Dutch policy was drafted. According to this document, Working Instruction 2015-9, the focus of the assessment lies on processes of awareness and processes of self-acceptance. The IND asks questions like, how did you deal with your sexual orientation? And what did it do to you when you noticed you had feelings for a girl? Through these questions, the IND hopes to learn about the veracity of the stated sexual orientation. But I found that asylum seekers often did not understand what was meant with a process of awareness or self-acceptance. They might never have heard of it, or they might not have experienced such a thing. These processes are borrowed from a staged model of sexual identity development that is predominantly based on the experience of white, middle-class Western men. So such a model cannot simply be applied to other groups, such as women or people from non-Western countries or asylum seekers. Furthermore, especially for asylum seekers with little or no education, it's very difficult, if not impossible, to reflect on their own sexual orientation and provide a satisfactory answer to questions about psychological processes. Sheet 4, please. I came across a number of other stereotypes in the assessment of the credibility of sexual orientation, and I will name some of them. While Dutch policy rules explicitly state that it cannot be expected that all LGBTI asylum applicants have experienced an inner struggle, in practice, people are still being rejected for a lack of struggle. The inner struggle seems related to the process of self-acceptance. First, you feel bad about yourself and your sexual orientation or gender identity, and later you reach the stage of self-acceptance. Anyhow, negative emotions are being expected. People who say they did not have inner problems, that Allah or God just made them this way, people who are proud instead of ashamed, or who were happy and gay because they were in love, run the risk of rejection based because they are not believed. Then there's the internalized LGBTI phobia. In Dutch policy, a connection is established between the environment and the mental processes which supposedly have occurred in the mind of the asylum seeker. An LGBTI phobic environment is expected to lead to problems regarding self-acceptance and becoming aware. And the applicant is expected to elaborate on this. However, I think it's more legitimate to assume the opposite. The more LGBTI phobic the environment, the more difficult it is for the person concerned to speak of their sexual orientation or gender identity. The EU Court of Justice ruled in the judgment ABC that it's no longer allowed to ask explicitly on sexual matters. And I think that's good. But now the assessment tends to go too far in the opposite direction. This leads to a new stereotypical idea in which it is expected that there are deep feelings, whereas talking about sex can lead to disbelief. The idea that sexuality has more to do with identity than with acts also plays a role here. And then we also have the stereotypical idea that coming out is a one-off event. The expectation that all LGBTIs are interested in the exact LGBTI-phobic provisions in criminal law in their country of origin, and the idea that they are all familiar with LGBTI interest groups and places of entertainment in the country of origin and in the Netherlands. There is the expectation that people always lock the door behind them, and never behave in a risky manner. And in case they practice a religion, it's assumed they struggle with the combination religion and soji. Here are my main recommendations. Sheet 5, please. How should immigration officers assess the sexual orientation of asylum seekers? One of the conclusions of the Fleeing Homophobia report was, as a general principle, establishing sexual orientation or gender identity should be based on self-identification of the applicant. In my opinion, it's simply not possible to assess someone else's sexual orientation or gender identity, and therefore it would be much better to rely on self-identification. The IND asked a woman from Nigeria, when is somebody considered homosexual in your country? And she answered, I don't think you can see it, but you can ask. Then you know. Or you go to a party together. It might be a nice idea if the IND visits parties together with the LGBTI applicants. But apart from that, this woman proposes to apply self-identification. In everyday life, if you wonder what someone's sexual orientation is, you might just ask this person. However, in asylum law and policy, self-identification is not easily accepted because the authorities fear false claims of straight people. Therefore, I formulated what I called alternative second choice suggestions. Sheet 6, please. Sheet 6? Oh, this is sheet 6, I'm sorry. Of course, sheet 6. Yeah. Oh, no, sheet 6. Well, yeah, great, thank you, sorry. Yeah, okay, and sheet 7. In addition, evidence other than the statement of the asylum seeker should be given more weight, especially statements of partners and other third parties, but also love letters, photographs of parties and trips with the partner. Yeah, sheet, what's it? 8. There are some recent developments to conclude with. In June 2018, my report was issued, and 2 days later, we spoke with the State Secretary. He had already read a draft version of the report, and he agreed with it on several points. He wrote a letter to the Parliament in which he announced the following changes in policy. The processes of awareness and self-acceptance were skipped from the policy rules. Also, it will be motivated what the IND does with statements by third persons. We were glad with these changes for the better. However, it's still unclear what the policy means in practice. Sheet 9, last sheet. Recently, the Dutch Council of State asked the IND critical questions about the situation. What are the differences between the two policy documents, the old work instruction and the new one? Are the comments of COC and other NGOs incorporated as it was announced by the State Secretary? And what about the Pride or Shame report? Are stereotypical expectations applied like a staged process of awareness and self-acceptance? We now wait for the judgment of the Council of State on this matter. And meanwhile, I started the follow-up research, of which the results will be expected somewhere next year. Yeah, oh yeah, of course. The IND says we have changed and improved the policy, but it's not a new policy because they're afraid that all rejected LGBT asylum claimants will file a new claim based on the new policy. So they say it's not a new policy, which I think it is. But in general, my opinion is that Dutch policy and practice is still relying on stereotypes and therefore in violation of the ABC judgment, as is the case in several other European jurisdictions. About the similarity in some of these jurisdictions, we will talk tomorrow in panel 20 on credibility 3. In this panel, we will also consider the relationship between stereotypical expectations and the use of the DISH model. This model will also be the subject of the next presentation in the current session. Tjelvan, the floor is yours.
Thank you very much, Sabine, for this really, really nuanced presentation that does remind us that asylum practice is a very elite space within which voices and experiences of those who do not conform to that white male stereotype are often marginalized. Thank you. And I think in this spirit, I do hand over to Tjelvan, who will talk about the emotional experiences. Thank you.
Thank you, Mange. I'm just going to share screen. There we are. Great. And start the... Okay. Yes, it's working. Great. I'd like to thank Soljika for inviting me to speak at today's conference, the title of which is The Emotional Journey and the DISH Model. Those of you who know me know I can speak for up to 3 hours, so I promise I'm not going to go anywhere near that, but there's quite a lot to go through, so let's kick off. First of all, we can see that there is change on a global level. This is an article in Pink News on the 27th of June, talk about Gabon decriminalizing. Our friends in Kaleidoscope Trust issued a map yesterday showing that there are currently 72 countries which criminalize same-sex attraction. So it's still a very dangerous world to be gay in. Now, as refugee lawyers, we know the history is steeped with respect to persecution of LGBT plus people. This is a picture in relation to the labor camps through Nazi Germany, and you can see the pink triangle attached to gay men, black triangle for lesbians, purple triangle for bisexual people. With the coronavirus, the COVID-19 pandemic, we are also seeing the added persecution and discrimination of LGBTQ people the world over. This is an article in Pink News on the 27th of March, looking at the issues in Ghana, where Muslim leaders are now targeting trans and lesbian people in relation to the COVID pandemic. Now, my three favorite words for those who know me are is knowledge is power. And I always believe that we, as those who represent queer refugees, have a duty to ensure that our refugee clients are empowered as much as possible before they go to claim asylum and get their applications decided by the authorities. Now, the title of the presentation is very important because I want to be able to share something which may not have been at the core of presentations you've heard so far in the conference about finding solutions. My role as a lawyer is to ensure that my clients get the best representation they can and be granted asylum. So none of us here in either UK, Germany or Italy or our partners across the globe will be doing this type of work if people were not granted asylum. Now, we see the alphabet soup in relation to definitions of queer identity, LGBTQ. You can see the rainbow list in there, the various global north power identities which you have there, which are in the main irrelevant to those who come and claim asylum here in Europe. So I like to start from the issue is that the reason why the individual is suffering persecution and claiming asylum is not necessarily that because they are LGBTQ, but they're not straight enough. Or more importantly, they're not cisgender or straight enough. They don't conform to the stereotype. And that's why I've coined the phrase, the queer refugee, to encompass all of us who do not conform to that stereotype. So let's get to the emotional journey. And our starting point, of course, is the definition of a refugee. Going back to Article 182, look at the purple highlighted terms within the definition of a refugee. Fear. Now, outside the country of a nationality or habitual residence, that's the physical journey. But we're looking at what defines a refugee, owing to such fear, unwilling to avail. So even within the definition of what constitutes a refugee for non-queer, queer asylum claims the world over, there is a distinctive attachment in relation to emotions, journey, physical, spiritual. Now, when we're looking at the different classes of refugee, we looked at the 5 different convention reasons, the individual can come within and express an actual convention reason or be imputed. Now, we talk a lot about not looking at stereotypes, but when we're looking at refugee persecution, there are stereotypes which exist, and those are the stereotypes that exist in the mind of the potential persecutor because of the nonconformity, not fitting in, being the queer refugee. Now, it's quite interesting that yesterday we celebrated 10 years since the handing down of the judgment by the Supreme Court in 8J Iran. It's amazing how the decade has just flown by in relation to how the development of the law from the reasonable, tolerable discretion test to the, well, you're a refugee, but if you voluntarily be discreet for personal social reasons, you are not a refugee. And a lot of my litigation strategy here in the UK courts is about getting rid of discretion. But currently, first limb, prove is or be perceived to be queer. The second limb, whether openly queer people in the country of origin face a well-founded fear of persecution, and the following limbs. Clearly, we're not going to be able to go through all of the limbs today. Looking at limb 2, it's very important to note with that, that's purely based on the objective country information. I know that in the Sojica presentation given yesterday by Nuno, part of the video says that the queer refugee needs to prove that they've been persecuted in the past. That isn't the case in the UK. You don't need to prove that you've been persecuted in the past to be a queer refugee. It may be part of the credibility assessment in relation to whether you can prove that you're LGBT+, but please note that a lot of my clients have been completely disbelieved in relation to the past narrative, but are now refugees because we've been able to show that they succeed under limb 1. But under limb 2, it's purely on the objective COI, country of origin information, about what happens to those gay martyrs in those country of persecution, not what may happen to you personally, because that is the second asylum. And you see the blue writing to LZ homosexuals Zimbabwe, an unfortunate case where the upper tribunal said that LGBT people in Zimbabwe suffer discrimination, but not persecution. But they did find that because of the individual profiles, the elite political links or the family connections, that individual is a refugee. So note that there are 2 asylum claims, the 8J Iran claim and the, in effect, the LZ Zimbabwe claim. So as I said, limb 1, prove is or will be perceived to be part of within the convention reason. It's purely a credibility assessment exercise on the subjective evidence in light of the country information, something which has been referred to by other speakers. But remember, you do not need to show past persecution to succeed under this limb. And also note its inclusion through actual or imputed convention reason. So in 2015, let's skip a few years, 2011, I started looking at in what way can we address what's been referred to in Milbank's article from discretion to disbelief. Because we know from the UCLIG report in 2010 that 98 to 99% of the 50 determinations analysed by UCLIG were accepted in relation to their sexual identity, but refused purely on reasonable tolerability tests. After the Supreme Court judgment in July 2010, the Home Office moves and proves that you're gay. So in 2015, 2011, I started looking at the concepts of different stigma shame, tied with my PhD studies at King's. And then in 2015, the Credo project, having done volume 1, looked at these issues in detail. And you can find this online, Google Credo, DSSH, and a Hungarian Helsinki committee in line with UNHCR and the Credo project. Chapter 11 in relation to asylum claims based on sexual orientation and gender identity. This is the starting point in relation to the written material in relation to what we're looking at. And in relation to stereotypes, again, stereotypes are what means to be gay, and we must exclude those stereotypes in relation to our assessments of handlebar moustache. It means that you are gay, and if you're a footballer, clearly you can't be gay. So those are the perceptions which must be ruled out. And as Denise gave in her presentation yesterday to us in exploring the Court of Justice case law, ABC gives us a clear prescribed blacklist of approaches which cannot occur. And that's a Court of Justice case in December 2014. Now, a lot has been talked about the way that the determining authorities look at the issue of the emotional journey at the interview. For me, the whole point is to create that safe space to the refugee client prior to claiming asylum, or at least prior to going to the interview. Because the role of the representative is to create a safe space and not necessarily ask questions, but actually be able to listen to the refugee and be able to hear their story. So that's why we're going to the DISH model. Difference. The first element in relation to the DISH model is difference. The fact that the reason why they're here claiming asylum is they're not the same as the potential persecutor, that they are recognized through their difference because they do not conform to the heteronormative stereotype of the potential persecutor. This is Kirsty, a 16-year-old schoolgirl, speaking in 2012 about knowing that she was different even in primary school. We're not talking about sexual awakening, we're talking about identification. Even the Court of Justice in the November 2013 judgment of XYZ made it quite clear when we're looking at inclusion of the particular social group, we are looking at the perception of the persecutor, recognized as different by the surrounding society. It's under the Qualification Directive under Article 10(1)(d), the second limb, recognized as different by surrounding society. Then, of course, we look at F in Hungary, the Advocate General's opinion, where the Court of Justice did not look at this issue in relation to final judgment, but even Advocate General Wall looks at the issue of being perceived to be non-gender conformative. So it's not about being LGBTQ, it's about non-conformity. So that's why the Credo project in the manual looks at these other issues. And I should say that Gabor from the Hungary Helsinki Committee co-wrote that chapter looking at the earlier presentations on this point. So it's about exercising the identification of difference. And this is where I put a red warning sign. None of this is in relation to negative feelings. Yeah, absolutely nothing to do with negative feelings. And we'll go to that at the end of the presentation. Difference is not about having detailed issues of feelings, but providing that narrative, knowing that it could predate. And importantly, the DISH model is not there to say that this is the only route to proving A. It is a positive tool through trigger questions. I remember going to a UNHCR meeting in Geneva on the 24th of June 2011 and having Aurum and the UNHCR saying, we need to have a questionnaire. And I said, over my dead body, because if we have a questionnaire of questions, they'll say, okay, 14 out of 40 questions answered correctly, you're not LGBT. If you get 39 out of the 40 questions correctly, and this is exactly what happened in the Somali minority clan cases, you've learned the answers from the internet. So we can't have questionnaires, we must be able to provide a linear narrative in relation to that. This is UNHCR in 2018 talking about LGBT voices. And this is Eli from Lebanon. His narrative, when I was very young, I knew that I was just very different from me. Recognition of difference. And the Home Office API on sexual orientation in asylum claims in 2016 looks at these issues in relation to the narrative of difference. Because of the time, I'm just going to put it up there. Please note it and read it at your leisure. Then we have stigma. Stigma, of course, comes from the Greek. It's where the Greek society used to brand with a hot iron in relation to those who felt outcasts. This is where the emotional journey starts, because clearly there will be stigma, because if there's no stigma, there's no fear, there's no persecution. So we're looking at refugee claims. Yeah. So the stigma after recognition of difference is where the narrative starts to develop. So focus on difference, not identity. That's why you should never ask a question about when did you come out. As Sabine said, there's no on-off switch in relation to a date where you came out. And that's why the question is never, when did you first realize you were gay, bisexual, lesbian? The question is, when did you first realize you were different? And this is a cartoon example from the Hungarian cartoonist in relation to different examples of stigma. Lawrence in Texas, Scalia J in 2003 talks about societal stigma against LGBT people, supporting the continued prohibition in 2003 of same-sex marriage in the United States. And ironically, those sort of references were then used in US Supreme Court cases to say that there was a constitutional right to LGBT because we couldn't support the stigma of these of queer people in the United States because it's clearly unconstitutional. Then we have shame. So if somebody says, well, what you are, who you are, is bad, and not even directly to you, but you see it through the TV, you see it through the community, through the family, then most people don't feel good about it. Yeah, and it's directly connected if you're told you are bad, then there is that struggle, there is that narrative, there is a detail. And this is in relation to internalized shame, not to the point of psychiatric mental illness, but the fact that that's normative. If you're told you're bad when you're in communities and in societies which persecute LGBT people, you're not going to feel good about it because that's directly connected to the causal connection to the fear of persecution. So there's a Rashid in Jordan saying, walking down the street, people would laugh at me. So they recognize his difference. They identified him as different. And he talks about the stigma which resulted and the internalized shame hiding in the closet. Chris Morris, one of the litigants in relation to the age of consent litigation in the UK, talks about nobody should ever soul search and wonder why their love is considered less worthwhile than other people's. Home Office API again, stigmatization, shame and secrecy, all components in relation to the refugee claim. And you can see the bullet points, a non-exhaustive list of bullet points in relation to that. This is another participant in the documentary said, I felt like a freak of nature. That's how he felt like in relation to the impact of stigma. And then of course, the last component of the DISH model is harm. The harm you fear or you have experienced or currently experience or will experience on the future return to the country of origin because of your queer identity. And this is another example from the Home Office API, a non-exhaustive list in relation to different types of harm and violence you would fear on return or have suffered in the past. Now, this is really important because as Sabine said, in the Dutch examples, the Dutch authorities concentrated very much on the issue of difference and issues of negative feelings in relation to the difference at a different stage of the model. So that is the incorrect approach. For example, when I trained the Swedish Migration Board in 2013, we looked at the DISH model. The Swedish Migration Board not only uses the DISH model in relation to queer claims, but also claims in relation to religion. What happened in 2017 is that they were having an issue in relation to interpretation of the model because there's something called the Juncker law in Sweden, where anybody who recognizes different is supposed to recognize feelings of negative feelings. So in December 2017, I went back to Sweden to say quite clearly, it's not linked to the issue of difference. You can see from the arrow, it starts in relation to the emotional journey in relation to stigma, shame and harm. So therefore, and as the 2015 Credo report actually said in the report, it's a feeling surrounding stigma and shame. It's a narrative of past and present experience of gradual recognition of difference, but the feelings narrative doesn't start at the different stage, it starts at the stigma and shame stage. So for example, in the last week, I've been instructed to give, draft an expert report in relation to a refugee claimant here in the UK claiming asylum, to be able to analyse the Home Office approach to the DISH model in relation to the credibility assessment, and that's been publicly funded. So the point is where things do go wrong is where there's an overfixation and a concentration on the feelings and emotional journey connection on the difference limb of the DISH model, where it should actually be to the stigma and shame. There's examples of the rhetoric in relation to the DISH model when it started in 2014. There's Newsweek talking about it's a simple starting point that cuts across borders. In 2012, UNHCR referred to it in the International Protection Guidelines. They've been using it for their global training since 2015 with IOM. EASA uses International Association of Refugee Law Judges. So the important thing is not to allow our refugee claimants to go to the interview and for the first time be asked those questions. I never allow any of my direct access clients to claim asylum until they've had the space, the time to be able to sit down and go through this narrative. I think it's exceptionally unfortunate for individuals to stereotype queer asylum seekers and say that a hairdresser from Uganda clearly can't give the same sort of detailed narrative as a blogger in Shoreditch. I mean, that is exceptionally arrogant and wrong. All my clients, if they're given the space and the time, and the solicitors I work with in big legal aid firms who have always used the DISH model in relation to the narrative, are able to give that space for the asylum seeker to speak and for us as representatives to listen. Here's an unreported case in January 2018 by the Upper Tribunal Judge Latta, where the Home Office accept in that case, and that's a case called BM, and in relation to that, with respect to if you provide a statement, on a DISH model statement after the asylum claim, but through the asylum proceedings, it is the Home Office policy to be able to re-look at that evidence in light of the DISH model. So the takeaways for here is focus on difference, not identity. These few cases is a 2005 country guidance case of gay men and bisexual men, those perceived and actual from Jamaica. It's still the country guidance case 15 years later for all Jamaican claims. And in that case, paragraph 71, I actually introduce the issue of respect to perception is all. It's not about being queer, it's about being non-conformative. And that's paragraph 72 in relation to that. It's about not seeing the norm of masculine identity in Jamaica. Now, in SW Jamaica, the country guidance case in relation to lesbian and bisexual women, this is 2011. Now, paragraph 3 is slightly concerning because it seems to sort of say that there are some lesbians who may want to be naturally discreet. But the power issues at paragraphs 4 onwards, where it accepted that even single women who aren't lesbian, but aren't able to prove straight, because women in Jamaica are supposed to be sexually receptive between 16 and 60. So if a potential persecutor comes to you, you need to either prove that you've got a male partner, have children, or recent evidence of widowhood. So on that basis, it clearly shows that the issue is not being lesbian or bisexual, but it's about being not fitting in. There is the most recent case of Iraq, SMO, which is December 2019, about not LGBT risk to not conforming to Islamic mores. And then there is a court appeal case in October this year about YD Algeria. I know there's been limited time. On the 29th of July, I'm speaking at a special session in relation to the University of Portsmouth in relation to Prove Gay. That's 29th of July. I apologize for the plug there. So that's an hour-long session. So please do register. It's a free session. So let's look about finding solutions. The UK does grant asylum, and this is one of my most infamous and famous clients, Adronco Pato, who, after being disbelieved when using the DISH model in August 2016, was able to tell her narrative, speak a narrative, and this outside my chambers in August 2017 after the Home Office conceded and granted asylum. So there we are. We're all here trying to ensure that our clients, that our refugees, gain asylum and gain safety. Thank you very much.
Wow, thank you, Chelvan. That was very powerful. And thank you so much for explaining to us this really powerful tool of the DISH model, which centers the voices and experiences of those at the center of the whole process, rather than thinking about satisfying institutional expectations. And that's really, really important to keep in mind. And with this, I would like to hand over the floor to Sophia. Sophia, if you could just say hi to us before we play your video, that'd be lovely. So we see your face. And
good morning to everybody. I would like to thank you for this very inclusive conference and for the chance to share our experiences. I pre-recorded my presentation just to be sure that I will not face any technical issue. So I hope that you will enjoy. Thank you.
Hello to everybody. I am really happy to be here with you for the SOGICA final conference, even if it is online. What I am briefly going to present you are the results from a survey of 60 asylum seekers cases that I conducted between July 2016 and February 2020 concerning the criteria and the methods that the Greek Asylum Service applied to assess credibility in asylum claims based on sexual orientation. All 60 asylum claims were rejected because the applicants were found non-credible, either non-credible sexual orientation or non-plausible incidents and facts of the narrative. Before I present you the results of the survey, let me first of all give you an image of the Greek legal framework. After the 1st of January, the implementation of the new law for asylum introduced radical changes both in asylum procedures and in refugee status determination. What became clearest than ever is that the acceleration of asylum procedure is the main priority for the Greek government in its effort to limit refugee and migratory flows. This acceleration, as the main goal, seems that can be achieved at any cost. Strict procedural burdens and punitive measures predicted by the new law reduced safeguards for people seeking international protection. Among the changes, a catalogue of 12 safe countries of origin was drafted for the needs of refugee status determination. countries like Algeria, Gambia, Ghana, Morocco, Senegal, Togo, and Tunisia, where same-sex acts are criminalized, are considered as safe countries of origin. Furthermore, the suspension of the Geneva Convention on March and the intention of the Greek state to refoul in Turkey even unaccompanied children and vulnerable people without previous registration and examination of their asylum claim was one of the most serious blows in the heart of refugee law that raised concerns within EU. Within this framework, it is obvious that the discussion around credibility assessment seems trivial in the view of a systematic transformation of the national refugee system which turns into a productive machine of rejections. Going back to the survey, the practice of rejecting applicants in credibility, apart from a turn in the case law after the abolishment of the discretion clause in the XYZ judgment of the Court of European Union, serves the aimed acceleration. Since credibility is the first stage of the examination of an asylum application, if the asylum seeker proves to be non-credible, the decision maker does not need to proceed to examine the well-founded fear and the persecution grounds in the country of origin. To begin with, it has to be noted that proving someone's sexual orientation is by default a problematic requirement that is met only in asylum procedures. Self-identification, as an aspect of the right to privacy, is one of the great values of the European human rights system. Although, in asylum procedures, neither UNHCR nor the Court of European Union accept self-identification as adequate element for the establishment of an asylum seeker's credibility. For UNHCR, self-identification is an indication of someone's sexual orientation, and for the Court of European Union is the starting point of the procedure. According to the Court, sexual orientation can be the subject of an expert's examination, as it is predicted in the Procedures Directive, but this assessment has to be in compliance with human rights. The Court doesn't define, though, what type of assessment could be this that can help an expert determine someone's sexual orientation. Even though all the decisions studied were drafted after the issuance of the ABC judgment, in which the Court elaborated on sexual orientation evidentiary matters, practice proves that the methods being used remain more or less the same, and steps towards a fair and harmonized common European asylum system are very slow, especially in topics where the Court's opinion was not absolute. The first issue studied was the questions about sexual practices of the applicant. Even though both UNHCR and the Court of European Union are clear, as they both consider that these practices violate applicants' right to private life, it's been observed that in 16 out of 60 studied interviews, applicants were asked to prove details about their sexual life. Questions like, "Tell us some details from your first time," "How long did it take?" or "I want you to describe me what you did when you met each other," were found in 6 cases. It has to be noted that in a case where the applicant avoided the question and did not provide the information asked, the caseworker insisted and tasked the applicant again to describe his first time. Also, during her interview, a lesbian woman from Morocco was asked to provide details about her corrective rape, among them whether she was sexually stimulated during her rape and how she felt while having sex with a man. In contrary to questions around sexual practices, Court of European Union and UNHCR are not so clear around the use of stereotypes. According to the Court, although an assessment based on stereotype notions cannot be the sole basis of rejection, because it could be contrary to an individual basis examination, stereotypes can be a useful element during the examination of the applicant's credibility. It has to be noted that the Court, in the ABC judgment, examined only the conformity of the practice with the common European asylum system and not with human rights. UNHCR's position around the topic was that the practice is not by itself against human rights, but it depends on its application. Out of 60 cases, 28 negative decisions contain in their reasoning stereotypes about LGBT persons. A lesbian woman from Cameroon was not assessed as credible because her first relationship was at the age of 39 and was already a mother of 3 children. This stereotype notion of parenthood and previous marriage as incompatible with LGBT sexual orientation was met in 4 other cases. On the other hand, a gay man from Cameroon was not found credible because even though he realized his sexual orientation at the age of 13, he had his first relationship at 20. This stereotype of late expression of sexual orientation as a basis for non-credibility was met twice in the research. Additionally, a gay man from Pakistan did not know the provisions of the penal law against homosexuality. And a gay man from Ivory Coast did not know about LGBTI's organizations and authorities' treatments towards LGBTI. Furthermore, what has been observed from the study is that in the majority of the cases, in 39 cases out of 60, the applicant is expected to have passed through a process of self-awareness and acceptance of their sexual orientation, as Sabine Jansen describes it in her study, which by default has to have been accompanied by a negative feeling. The applicant has to be in a position to perceive their sexual orientation as an element of their identity, to specify the time of self-discovery, and to provide details about the experience. In the reasoning of the decisions we read, the applicant had no difficulty in the acceptance of her sexual orientation. The discovery of sexual identity is a focal point in the life of every human being, especially when it deviates from the socially acceptable rule. Certainly, this process is governed by a lot of tough and hard emotions. However, none of these internal processes reflected in the applicant's responses. The applicant was vague and did not clearly state how and when he realized his sexual orientation and on what occasion. The applicant was unable to clarify how he perceived his sexual difference. The explanation for how he felt about his first relationship were vague and he did not provide details. And of course many more. These expectations, that can be described as a second generation of stereotypes, are in compliance with asylum services provided by UNHCR and EASO's internal guidelines and are considered a legal and compatible method. Although this perception that the discovery of someone's sexuality is a linear process which is hard and shameful that defines their identity is rather a Western notion of sexual development and does not apply to all LGBT applicants. As a gay man from Iran states in his interview, "I never thought that what I was doing was wrong. The only thing that was wrong was the country that I used to live in." It is humiliating to expect from this man, under the threat of being perceived as incredible, that he has to have a negative opinion about himself. In addition, in many cultures, even though faith, ethnicity, and tribe constitute someone's identity, sexuality is only a matter of attraction. Even though for a white man that was raised and studied in London is rather easy to define himself as a gay man, for a woman that was raised in Kabul and has never attended school, this identification may be impossible. Although the fact that an applicant is not able to describe in detail their internal process and express their deep feelings doesn't make them less LGBT. We have to admit that Western society does not possess the absolute privilege of sexual minorities. Another issue studied was the use of evidence. According to the Court of European Union and UNHCR, applicants are not supposed to provide evidence such as film and photos as proof of their sexual orientation. As it is stated in the ABC judgment, such demand could infringe applicants' dignity, it does not necessarily have a probative value, and would incite other applicants to provide such evidence. From the studied files, only in one case a gay man from Iraq has submitted photos of his sexual life during his registration. These photos haven't been taken into account because, according to the caseworker, he had not a probative value. Furthermore, in 2 cases, the applicants were not allowed to provide photos on their own will during the interview. In the first case, the applicant was about to submit a screenshot of his conversation with his father, where he was threatening him, and in the second, the applicant would like to submit photos of himself and his partner that were uploaded in Iran's social media. Although, by default, court's prohibition of assessing photos and videos in credibility assessment is a safeguard for LGB asylum seekers, as it is concluded from the studied cases, it should have been interpreted that this prohibition does not cover non-pornographic evidence and materials that are already public in the country of origin. Another practice that was observed in the study was the tendency of the caseworker to guide the examination around certain facts and incidents, in many cases not crucial to the applicant's story, to identify small inaccuracies in the narrative, and as a result, to conclude that the stated events did not happen. This practice was met in 15 cases. In one of them, an applicant who was diagnosed with PTSD was found as non-credible because, among others, in one point of the interview she stated that she was raped around 12 o'clock and in another around 2. In other 5 cases, the rejection of the applicant's sexual orientation was totally arbitrary without a reasoning in the decision. In 2 cases, the applicant was found incredible because, among other factors, the criminalization of same-sex acts in the country of origin is not actually applied. In one more case, in which the applicant was finally granted asylum in the second instance, even though he was found credible about his sexual orientation, he was not believed as facing a well-founded fear of persecution, since in Iran he could hide his sexual orientation and he never received an attack. The poor quality of these decisions reveals the desire of fast-track rejections and the prejudice against LGB asylum seekers on part of the Greek Asylum Service. What we can conclude from the study is that despite further elaboration on the topic in a European and international level, and the establishment of at least forbidden methods, the Greek Asylum Service uses practices to assess LGB applicants' credibility that are compatible both with refugee law and with human rights standards. From one side, we observe illegal practices that are not harmonized with the court's interpretation of EU law and UNHCR's position, such as the questions around sexual practices of the applicant and the extensive use of first generation of stereotypes. From the other side, the extensive use of practices such as the stereotypical requirement for all LGB refugees to have passed through a hard process of acceptance of their non-conforming identity jeopardize their right to self-determination. It is contradictory that from the one side, LGB asylum seekers are not expected to conceal their sexual orientation in their countries of origin, as the court has ruled, but from the other side, they are not supposed to decide who they are. The typical reasoning of the unable to provide details about their feelings and experiences applicant is met as a leitmotif in most of the rejective decision, often without further analysis. This repetitiveness that proves the lack of individual assessment deprives from the method any of its probative value and highlights the necessity for further elaboration from advisory bodies and agencies as UNHCR, EASO, and International Commission of Jurists. Thank you very much for your attention.
Wow, thank you very much, Sophia, for this wonderful talk that I think brings home and drives home so many points that we have also discussed in Chelvan's and Sabine's presentation in terms of the need of a true intersectional lens in order to grasp these experiences and trying to make sense of these experiences, in the process of the establishment of credibility.